The Minnesota Voters Alliance versus Mansky. I'm Steve Ray, and this is Scholars Mate. Hello and welcome to Scholars Mate. I'm your moderator, Steve Ray. The Supreme Court has taken up a case from Minnesota this term that could have major implications for the First Amendment in democracy's most sacred place, the voting booth. In 2010, Andrew Sillick, executive director of the Minnesota Voters Alliance, wore politically themed apparel to a polling station, only to be charged with violating the state's law prohibiting such apparel near polling places. Sillick then sued. Now here's how the Pacific Legal Foundation, which is representing the Minnesota Voters Alliance, explains the issue. Take a look.
We're not just fighting for voters in Minnesota that want to wear a Tea Party shirt that say, "Don't tread on me," or "Liberty." We're fighting for small business owners in Tennessee who want to wear Chamber of Commerce t-shirts. We're fighting for union members in New York who want to wear AFL-CIO shirts. We're fighting for sportsmen in Texas who want to wear NRA shirts. And we're fighting for civil rights advocates in Vermont who want to wear shirts that say NAACP.
So does the Minnesota law violate the First Amendment, or is it a reasonable restriction on free speech? Joining us to discuss the issue, a great panel today. Gracia Hillman, Vice President for External Affairs at Howard University here in Washington, D.C. She served as chair of the U.S. Election Assistance Commission, president and CEO of the World Space Foundation, senior coordinator for international women's issues at the U.S. Department of State, and executive director of the League of Women Voters of the U.S. Congressional Black Caucus Foundation and National Coalition on Black Voter Participation. She is also a member of the National Association of Parliamentarians. And also joining us is Ilya Shapiro, Senior Fellow in Constitutional Studies at the Cato Institute and Editor-in-Chief of the Cato Supreme Court Review. He is the co-author of Religious Liberties for Corporations, Hobby Lobby, the Affordable Care Act, and the Constitution. Yes, that's the complete title. As coordinator of Cato's Amicus Brief program, he has filed more than 300 Friend of the Court briefs in the Supreme Court, including for this very issue. He clerked for Judge E. Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit. I appreciate you both being here. Thank you so much.
Good to be on.
Thank you so much.
I appreciate that. Now, we're going to start with you, Ms. Hillman, and I'll give you both equal time on every one of these questions. But in a minute or so, would you give a brief overview of what you believe this case is about for the layman? Is it voter suppression? Is it a First Amendment issue? Or is it a combination of both?
Let me begin by saying I appreciate the opportunity to be a part of this conversation. It's important that conversations like this happen across the United States so that people with different perspectives can come together and share information and find the common ground, the middle ground. There is one out there. The rub between election administration and how people feel infringed upon if they feel like their vote is either being suppressed or somehow discouraged creates tension, and rightfully so. I mean, as you opened up, the voting booth, the polling place, is a sacred place for voters to be on election day. And by the time the voter walks into the polling place, they want to have a bit of a break, if you will, and to be able to have clear thought, go in and cast their secret ballot. Anything that's too broad is always an issue, and you won't get any argument out of me on that score. But I think it is appropriate that election officials are able to set regulations so that people don't do something that would bump up against electioneering.
Okay, that makes sense. Now, Mr. Shapiro, is this government overreach?
Well, it's government overreach in the context of censoring expression. Nothing more or less than that. And I agree with Gracia that certainly we don't want to have chaos or confusion or distractions or intimidation, these sorts of things, or electioneering for that matter, right inside the polling place. You don't want people to be intimidated or concerned or confused when they're exercising their very important right to vote. But this is not a case of regulating that you can't electioneer within 50 yards or 100 yards or whatever the standard is of a polling location. It's simply that, and in fact, when people ask me a legal question, I sometimes like to look at the actual legal text.
Please
and
do.
the Minnesota provision says, quote, a political badge, political button, or other political insignia may not be worn at or about the polling place on primary or election day. So this is nothing about someone yelling or speaking or trying to convince anyone. It's about wearing clothing or buttons or paraphernalia of that sort. And I think to say that the way that it's written so broadly to include anything with some sort of political message, well, that's not just Republicans and Democrats. In this case, it was a Tea Party shirt. It could be a union jacket. It could be Chamber of Commerce. It could be the Cato Institute,
Well, let's
representing a
get into
libertarian
that,
interest.
because the Minnesota Voter Alliance has said they want this case to define the ability not only to wear a T-shirt or a button with a candidate's name on it, but as you said, perhaps an AFL-CIO union logo, a Don't Tread on Me Gadsden flag, right? Tea Party themed shirt, or even an NRA hat or NAACP patch on their jacket into the polling place. So this cuts across the board, no matter where you are in the political spectrum. How does this compare to the basic law in many jurisdictions that doesn't allow campaign signage within, say, 100 feet of a polling place? What is the difference here?
Well, I think we're talking about two different things. I mean, every voter who's gone to vote in person at a polling place knows how the sidewalk is lined with people with campaign literature and support my candidate or support this issue. Once they step inside the polling place, it's supposed to be about the administration of election, best practices. And so guidelines have to be set so that there isn't a subjective decision as to whether 75 people in a row with a slogan, I'm the Tea Party, I'm the AFL-CIO, knowing, the community knowing that both of those entities have vocally and actively campaigned and supported either a candidate or an issue. So the voter might take a look at that and step back and say, well, I'm not going in there right now. I'm not sure what's going to happen. So I think it's right for election officials to be able to say, campaigning outside of the polling place, 30 yards, whatever, not yards, 30 feet or whatever the distance happens to be. But then to be able to describe in clear terms what does constitute campaigning or electioneering. For example, if something's on the ballot and people walk in with slogans that have a clear message about the item that's on the ballot, that's very suggestive.
Right.
And if they strategically line up so that 25 of them are coming in the polling place at the same time, there's a very clear message there.
All right, we will get into the forum, the spacing, and the different ways those ideas are expressed, but are you in fairly reasonable agreement with that assessment about the difference between the signs being limited to a certain footage outside of the polling place and what you can bring into the polling place before we move on, or is there a
Until
little
she
difference?
got into the very end of her statement there, I was in complete agreement.
Okay.
Because what we're talking about here with this Minnesota law and ones that are similar to it in other states is about restricting the voters. I'm fully on board with you can't have campaign workers, activists going in trying to convince workers, voters, what have you. But if a voter's wearing a T-shirt or a hat or a button, something that is not intruding on anybody else's ability to go to the polling place undisturbed, unmolested, unintimidated, that's fine. But I don't think a T-shirt is doing any sort of intimidation or what have you. Certainly not, I mean, maybe if there's some racial epithet or something like that, but certainly not something with a political or religious or other kind of slogan that has any relationship to the public discourse.
All right, I'm going to get into where we draw the line on those particular slogans and logos and so forth down the line here, but I want to ask you, can the state create free speech zones when courts have held that bans on First Amendment activity are unconstitutional regardless of the forum, and specifically, when across the board there isn't really any agreement at the circuit court level on any blanket bans on political speech? And
Well,
I'll ask you the same, by the way.
The whole country is a free speech zone. The question is, what kind of restrictions are allowed to that whole country free speech zone? So, for example, political speech is very protected among other types of speech, but that doesn't mean that I can go to your neighborhood with a megaphone at 3 o'clock in the morning and start conveying my views. There are what are
Although
called,
there are guys who do that.
well, and it's proper to
You haven't
restrict
been to my
them.
neighborhood,
It's
but I
proper
know
to
what you
restrict
mean.
them because there are what courts call time, place, and manner restrictions.
Right.
So just like I don't believe that the government should be able to ban pornography, for example, if you're consuming it in the privacy of your own home, that's different than someone who's putting up a pornographic billboard in the middle of the street. Again, time, place, and manner. So similarly, if you can engage in electioneering in a lot of places, you cannot do that inside the polling place because that would disrupt things. But I don't think that wearing a T-shirt or a button is that kind of disruption or confusion.
So where does this go as to the confusion at the circuit court level, where there isn't really a level of agreement across the board, which is why obviously this has to go to the SCOTUS level, which it will, by the way, in February, late February of 2018. How does that play in terms of jurisdiction by jurisdiction, allowing states to make this a state issue as opposed to now at the SCOTUS level being a national issue because the circuit courts can't agree on this?
I think states have the responsibility to put in place reasonable procedures and policies and rules to be able to define an issue, to define what constitutes electioneering in a particular jurisdiction. I have not met a campaign worker worth their salt who isn't very creative as to how they use an opening to be able to get a message into a place where maybe normally you wouldn't see it there. So I think election officials have to be able to draw the line and say, no, I think this has gotten across the line. It's not just Gracia Hillman walking in with a T-shirt on that says, support a woman's right to choose.
All right.
Okay? But that if Gracia Hillman comes in with 100 colleagues and we all have on a message T-shirt and that message is on the ballot, the purpose of a T-shirt or a button is to convey a message and hopefully invoke a conversation. You want somebody to know what that message is about. So you're standing in line, and we've seen long lines at polls, okay? And you're standing in line and people are having conversations about things. But I think that there is, unfortunately, a way that the ability to come into a polling place with any message on a button or a hat could, in fact, end up to be a situation where election officials are going to have to make a decision.
All right, I'm going to revisit part of that in a little bit, but how would this affect corporate expenditures for political purposes? Maybe it doesn't, but especially when it's not at the polling place but does involve free speech. Let's say a pharmaceutical company prints up 1,000 T-shirts that support the legalization of cannabis in that locale. Now, the additional twist to this is there isn't a cannabis issue on the ballot. Should that be restricted? Should that fall under this ruling? Or should corporations be allowed to make those expenditures for political purposes, even though they may be pushing an issue that's coming up further down the line?
Well, it doesn't matter whether the spending on the political speech is made by corporations or rich individuals or a collection of individuals or political parties. I mean, in this case, this kind of goes beyond the sphere of regulating, politicking or non-politicking within the polling place. But to use Gracia's example, if you're really going to coordinate 100 voters, because remember, this is not just activists bust in from who knows where, but they're on the list for that particular precinct, for that particular polling place. If you're going to coordinate 100 people to come through with the same T-shirts, with the same message at the same time, I mean, that's a lot of work. But if you're going to do that, I still don't have a problem with it. Because whether they're paid for by the pharmaceutical or anybody else, whether they have a message that's related to a ballot initiative or not, because at the end of the day, a T-shirt does not threaten American democracy. Now, if those people are going to intimidate other voters in some manner by saying you're not really going to vote for that, or try to argue with them in some way, make them feel unwelcome in the ballot area, that's another thing. But simply, even if you have a coordinated 100 voters who are properly in that precinct, all wearing the same message, that's American democracy in action. I don't see anything threatening from it.
All right, let's turn the corner a little bit. The gentleman was cited and arrested, apparently, for wearing this T-shirt and not allowed to vote. Who controls this controlled environment? And does this create prosecutorial discrimination based on whoever that precinct captain might be or whoever is in control? And we'll start with you.
With guidelines that are too broad, I can see where it could. I think that it's the responsibility of the election officials to be as clear as possible and to be as prescriptive as possible so that the poll workers understand what the process is. Not only what the issue is, but if I'm confronted with this, if I have a question about this, who do I turn to? Remembering that the overwhelming majority, hundreds of thousands of people across the country who are poll workers are volunteers.
Oh, absolutely.
And it may be the very first time they're there. So they should not be left to have to make a decision about whether that's right or not, but that it is the election official and the paid election administrators in that area who should be very clear as to how a decision gets made.
Is that agreeable?
That the rules have to be clear from the beginning and laid out in a reasonable manner by the election administrator? Absolutely. But the question here that the Supreme Court is going to look at is what's the baseline? What is the level below which that the administrator simply does not have the power to restrict? Maybe some administrator would like everything completely orderly and you can only vote if you're wearing, I don't know, white shirts and black pants, because otherwise it gets too jumbled and too confused. You have to be in a line like this and wants to put in all sorts of rules and regulations that are unnecessary. I mean, is it more orderly? Sure. You can have lots more order, but
let's go to that then.
Infringes on people's freedom.
Let's go to that then. Not that all people who wear white shirts and black pants would be waitstaff who would be allowed to vote, but let's decide or talk about this. Who decides which apparel is political in nature? If it doesn't have a logo or a saying on it, perhaps it's just a solid red or blue shirt in keeping with how we denote wins on a political map.
Well, I think
where does that line get drawn?
There's reasonableness. And I think that if the election officials and the community groups and the campaign workers and others in the community are having a conversation about where that line is drawn. Now, too broad, blue T-shirt, white T-shirt, no, that I haven't heard of that. But I think that it's fair to be able to say, if there's an issue, if there are referenda on the ballot, candidates on the ballot, that the messages should not be supporting or opposing those messages in the polling place.
So that's
beyond
that, red T-shirt for Democrats or blue for Republicans, since we know that's how
most voters
wouldn't.
Most voters wouldn't get that. Most voters would. Campaign workers, absolutely.
What
but
about
most voters wouldn't
cases
get
from
that.
Minnesota?
Right.
What they have ballot initiatives about building stadiums for the Minnesota Vikings, for example.
And
what
if they all wore purple and gold,
that's
or
right. That's right.
All right. Do you think? I'll ask you this first. Do you think some voters might chill to the idea of going to a polling place if they might be subjected to arrest for what they're wearing, even if there was no intention?
The question isn't whether anyone would be chilled. The question is, what is the government's justification for this? Because normally, we don't ask whether someone has a good enough reason to exercise their rights. We ask whether the government has a good enough reason for restricting your rights. And so I would pose that question right back at Gracia and say, what really is the harm of a T-shirt carrying a slogan?
And does that invoke voter suppression if someone is perhaps scared of wearing something inappropriate?
So having a good conversation like this, you don't see the harm.
Exactly.
Having written rules and regulations, and you don't see the harm. But it is when people push the envelope that the situation is created, and it has to be resolved on the spot. And we know from over the years, people are going to push the envelope.
Sure.
They're either going to push the envelope to test something they don't like, they're going to push the envelope to irritate some other candidate, or because they don't like the referendum item. So it's usually on the spot when it has to be resolved.
And with that, we go to your questions. This is from Sherry Hampton, who says, voters shouldn't be harassed at a polling place, but how is wearing a T-shirt or button harassment?
It depends what the message is on the T-shirt and the button. I might find something very offensive that may or may not have anything to do with what I'm voting on. But there are messages that can be very offensive to a lot of people.
Especially in the age of perhaps even the vision of our current president, a rainbow flag in a highly religious area. How is that, to answer Ms. Hampton's question, how is that considered harassment, if it is?
It's simply not. A T-shirt can't harass someone. I mean, especially when we're talking about political messages. I mean, sure, you can have all sorts of racial epithets or other offensive things. That still wouldn't be harassment. It's a different sort of thing, but it's not arguing for a particular ballot initiative or a candidate or a party or something like that. So, yeah, that's ultimately that viewer. I agree with the implication there. I just simply don't think it's harassment or intimidation.
All right, we'll start with you on this question. This is from Dominic Tran. Isn't the distinction between political candidates and nonpartisan language irrelevant? What difference does it make whether I wear a Bernie for President T-shirt or a Gadsden flag button?
Sure. Wear those sorts of things. That's your First Amendment right to do so, as long as you're not, again, getting up in somebody's grill, as came out during the Snyder versus Phelps protests at military funerals by the offensive Westboro Baptist Church. They also have First Amendment rights. So again, it depends on what you're exactly doing, and simply holding, having some sort of paraphernalia that you're wearing does not disrupt somebody's voting process.
And I would agree, it doesn't disrupt the voting process. Can it be harassment? Sure.
All right, now it's time for something we call Answer This, where each guest asks a question directly to each other. Would you like to go first, Ms. Hillman?
My question would be whether the hope is that the outcome of this case paves the way for something else, or is it really because the issue couldn't be resolved with the Secretary of State and the election officials?
Well, I don't know the motivations of the Minnesota Voters Alliance or the individual plaintiffs in the case. I know that my interest, unlike in certain other campaign finance or other First Amendment or even other types of legal areas, I don't see anything beyond this. I'm certainly not advocating that we open up the polling place to full electioneering and marching bands and activists and things like this. I'm simply saying that there's a difference between that and the simple wearing of buttons and T-shirts.
Your question to Ms. Hillman.
Well, again, what is the harm? Assuming away the issues of someone directly being obnoxious or physically violent or abusive that would intimidate someone away from the polls, what is the harm of the most direct message, vote for candidate X, or Republicans are good, or Democrats are good? What is the harm from those types of political slogans, let alone merely logos of some organization that may or may not be on the ballot?
I will draw the line between, if it addresses something that's on the ballot, then I think it has to be, there have to be procedures in place somewhere, because human beings can't help themselves. They take advantage of situations. And that will happen in the polling place. And without those guidelines, without the clear rules spelled out in advance, somebody is going to have to make a decision on the spot if something happened that was not intended. And that puts the burden on the election official to have to make what some people would say a subjective decision as to whether or not. I mean, if somebody comes in with a Bernie Sanders for President T-shirt at a 2018 election, I don't think anybody's going to pay any attention except to say there's a Bernie
It's
Sanders
still covered
support.
by the Minnesota law, however.
Well, I'm just saying, when a law is too broad, as I started out, it does create issues for people on both sides.
And would you agree, both of you, that there would be many firsts where decisions will have to be made based on whatever is presented as that problem, whether it's a T-shirt, a hat, a color,
But I think
maybe
things
not
can
even
be
politically oriented?
I think things can be worked out in advance because election officials have seen it all, and community activists have seen it all. So I really do think that if people sit down and have a conversation that says, what are the things that would be considered interfering, and how do we work around those so that people feel their First Amendment right, their right to free speech isn't infringed on, but that it can't create a situation where in the polling place we're going to have people feeling like they're getting messages they don't want to receive in the polling place. This is my place to cast a secret ballot. I would like to do so in peace and quiet and privacy.
All right, now it is time for We Agree, where each guest names something the other said that he or she agrees with.
Well, I agree with restrictions on electioneering and other disruptions within the polling place. I think that that line of precedent by the Supreme Court is correct, but this is not that, and that's where our disagreement is.
And something that Mr. Shapiro said that you agree with?
Well, I would agree that a single instance of a T-shirt, a jacket, a cap, a button is not really the issue. The issue is where the lines are drawn so that people know in advance that if you're coming in with a message that is clearly going against the spirit of no electioneering in the polling place, then people should know in advance that's what that is.
Well, let's be clear. No electioneering means outside people, not voters. Voters are rightfully there to vote, and they're not there to convince others, other than if they're wearing something. They shouldn't be shouting at other people saying, "Vote for this guy,
No,
vote for that guy."
I would agree, but I think campaign workers would come in with their message T-shirts.
Spirited, but respectful. That's the way we set out to do this show to begin with, and that's all the time we have. We would like to thank Gracia Hillman of Howard University, Ilya Shapiro of the Cato Institute for joining us to discuss this issue. Thank you both for your time. This has been fantastic. And thank you for watching, Scholars Mate. I'm Steve Ray. We will see you next time.